Assalamualaikum warahmatullahi wabarakatuh. My name is Syafawatul Husna and my group members consist of Hayatul Husna and Aina Azmeeza. So we are from Syafa and Associates. Now we will present regarding trial and pre-trial case management on the topic of offer to settle. An offer to settle is a mechanism provided under rules of court where a defendant makes an offer to settle to a plaintiff, and it is an offer of compromise which may be invoked by parties to a proceeding to tempt or to pressure their opponents to compromise or to settle before the matter is decided by the court. Offer to settle falls under Order 22B of the Rules of Court 2012, where the offer to settle mechanism replaced the previous method of payment into court. However, the principles remain the same. Previously, a payment into court could only be initiated by the defendant, and such mechanism was only applicable to cases where the claim was monetary in nature. It was also not available in a third-party proceeding. But under the new provision, the offer to settle procedure is now available to both the plaintiff and also defendant in the proceeding, the parties as well as parties in a counterclaim. It has also been extended to include non-monetary claims. Furthermore, the party making the offer does not have to make advancement of money as in the previous rule payment into court. Nevertheless, the purpose of offer to settle remains the same as payment into court, which is to reduce costs and to encourage settlement of proceedings. So, what are the procedure for making offer to settle? Firstly, a party to any proceedings may serve on any other party an order to settle in Form 34. An offer to settle shall not be filed, nor should its existence be included in any pleading or affidavit. Further, as long as the offer to settle is not accepted, any communication of such offer shall not be made to the court until the matters in relation to liability and relief to be granted is determined. Next, an offer to settle may be made at any time before the judge decides on that matter. An offer to settle is considered confidential and privileged. Hence, an offer to settle is made without any admission to liability. An acceptance of an offer to settle is by serving Form 36 to the offering party, and for the withdrawal in Form 35. If a party fails to comply with the accepted offer to settle, a party have two options. Firstly, make an application to a judge for judgment in terms of the accepted offer, or secondly, continue with the proceedings as if there had never been accepted offer to settle. What if there were two or more defendants who should make offer to settle? Under Order 22B Rule 10 of the Rules of Court 2012, it stated that if there are two or more defendants and the liability are not joint and several, then an offer to settle may be made to any of the defendants. However, if the liability of the defendants are joint and several, then an offer to settle must be made to all the defendants. Other than offer to settle, there is also offer to contribute, which regulate under Order 22B Rule 11. Offer to contribute means that when there are two or more defendants at any of the defendants makes an offer to contribute to the settlement in Form 37 to another defendant, the court would consider this as offer to contribute. The codification of an offer to settle originated from the English case of Calderbank and Calderbank, which is known as Calderbank offer. This case involved matrimonial proceedings. In that case, the wife made a reasonable offer to settle the dispute and the husband rejected that offer. The wife got a better result when the matter proceeded to court. The court considered that the husband was unreasonable by rejecting the wife's offer to settle the dispute prior to the hearing of the matter. Therefore, an effort made to settle a dispute is to be on without prejudice basis, without being made known to court until the matter has been determined. This is to ensure that the court is not be influenced by the fact that an attempt to settle the matter was made. In this case, the court decided that if a winning party in litigation refused an earlier settlement offer, the losing party may produce the settlement offer as a proof towards the appropriate level cost payable. Next, we go to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Aina Azmeeza binti Azmi, and now I will continue with the next issue in offer to settle. So the issue is, what if the offer was not done in the prescribed form? So under Order 22P, Rule 1 of Rules of Court 2012, it is stated that a party to any proceedings may serve on any other party an offer to settle in Form 34. However, if we refer to the case of Chun trading as Image Galaxy Amara Hotel Properties, year 2008, Singapore High Court, page 24. Okay, this is a Singapore case where the defendant made an offer to settle the dispute 2 years before the assessment of damages was disposed of by the court. But the offer to settle was not made in the form prescribed by Order 22A of Rules of Court Singapore, which is equivalent to Order 22B of Rules of Court 2012. However, the court held that although the offer to settle was not made in the prescribed form, it was still taken into consideration by court. So this shows that the wrong use of form does not amount to incurable irregularity, and so the offer to settle is still valid. Then we move to another issue, whether under Order 22B Rule 2 of Rules of Court 2012, it is stated that an offer to settle may be made at any time before the court disposes of the matter, and Order 22B Rule 3 of Rules of Court 2012, it is stated that where an offer to settle specifies a time within which the offer may be accepted, and it is not accepted or withdrawn within that time, the offer shall be deemed to have been withdrawn when the time expires. And when an offer to settle does not specify time for acceptance, the offer may be accepted at any time before the court disposes of the matter. And the notice of withdrawal of the offer shall be informed. Understand better these two rules, we refer to the case of Ho Chi Meng and Yang Chong Realties Niam Berhad, year 2013, volume 7, Malayan Law Journal, page 539. What happened in this case is that the petitioner filed a winding up petition whereby the respondent offered to settle the sum of 21,917 ringgit and 65 cents claimed under the petitioner's Section 218 of Companies Act 1965 before the matter was disposed of by the court. The express term of the offer was made on the basis that the payment would absolve the respondent of the debt under the judgment. So the finding of the case is that the parties then reached a settlement to settle the amount of 24,708 ringgit and 48 cents, and as a result, the winding up petition was then withdrawn. So from this case, we can see that Rule 2 and 3 of Order 22B are applicable, whereas the offer made by the respondent was done before the matter was disposed of by the court, and the petitioner also accepted the offer before the matter was disposed of by the court, and hence why the winding up petition was withdrawn. So that's all my points on offer to settle. We move to Hayatul Husna for another issue.
Assalamualaikum warahmatullahi wabarakatuh. Now I will continue presenting decided cases about an offer to settle under Order 22B of Rule of Court on the issue of cost, which is provided under Rule 9. Briefly, under Order 22B, Rule 9, Sub-Rule 1 of the ROC, it stated that if an offer to settle is accepted by the plaintiff without providing for costs, therefore, each party shall bear their own costs. Meanwhile, Sub-Rule 2 provides how the court will determine costs when a defendant makes an offer but is not accepted by the plaintiff, and then later the plaintiff obtains a judgment in its favour. Based on Sub-Rule 2, if the plaintiff obtains judgment with a sum that is not more favourable than the terms of the offer to settle, or in a simple way to explain, the plaintiff obtains judgment with a sum that is less or just the same with the terms of the offer. Hence, the plaintiff will get costs from the date of the trial to the date the defendant made the offer. However, the defendant also is entitled to get costs from the date the offer was served to the plaintiff to the date of the judgment. Next, we move to the decided case. The first case is Hasnul Hanis bin Badrol and Alliance General Insurance Co. M. Berhad, reported in 2019. In this case, the plaintiff was the insurance agent of the defendant under an agency agreement entered between both parties. The plaintiff's agency was terminated and the defendant admitted to liability for wrongful termination of the plaintiff. That is the brief facts of this case. Now we focus on the issue of costs. In this case, the defendant has made an offer to settle with a sum which exceeds the damages awarded by the court towards the plaintiff, but it was rejected by the plaintiff. The court decided on the issue of costs by referring to Order 22B, Rule 9, Sub-Rule 2, Paragraph B, and held that the plaintiff is entitled to costs to the date the offer was served, and the defendant is entitled to costs from the date the offer was served to the date of the judgment. This judgment illustrates the application of Rule 9, Sub-Rule 2, since the plaintiff obtains judgment not more favorable than the terms of the offer. The last case is Dr. Gurmai Kaur, anak perempuan Sadhu Singh, and Dr. Teh Siong Peng, reported in 2014. This is a divorce case whereby the petitioner is the wife and the respondent is the husband who were dissolving their marriage. Under the maintenance order, the respondent paid the petitioner a sum of Rm 11,000. However, the petitioner asked for a higher settlement since they have 2 children who are undergoing medical training in Australia. The court in this case determines the cost of orders for custody and division of matrimonial assets by referring to Order 22B, Rule 9, Sub-Rule 2 of the ROC. Since the respondent had previously made an offer to settle with terms not less favorable than the judgment obtained by the petitioner, but was rejected by the petitioner, therefore, the respondent is entitled to costs from the date of the offer was served until the date of the judgment from the petitioner. Hence, it also shows the application of Order 22B, Rule 9 of the Rules of Court. With all that being explained, that's all from us. Thank you so much for listening.